about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody. Welcome to the show. Today, our topic is how to purchase and own property subject to existing loans and not pay any taxes. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. Subscribe to our channel. You can find us on Facebook, and you can find us on YouTube. On YouTube, we are at INREM Podcast. That is at INREM Podcast. With that, we're going to go to Sean for our legal update.
Thank you, Andy. So today I want to talk about and actually give a little preview of some upcoming seminars I have later in this week dealing with the legality of subject to transaction. In fact, we're talking about SubTo tax-free today. So one of the things that I receive a lot of feedback from investors on is working with attorneys that aren't familiar with subject to transactions, aren't familiar with wrap transactions, and even working with real estate agents and trying to accomplish a subject to or a wrap transaction with real estate agents. And one of the pushbacks that they receive from both attorneys and real estate agents who aren't familiar with the transaction are, hey, it's illegal. You can't do it. It's against the law. And so I want to talk a little bit about that. Number one, there are plenty of legal authorities and even publications by the federal government, by the state, states that contemplate subject to transactions. So for example, in Arizona, we have a statute talking about agreements for sale. And in that statute, it lays out the timeframes for a forfeiture. And as you know, Andy, our forfeiture laws provide that there are certain time limits on the ability to execute and complete a forfeiture on an agreement for sale. And those time limits are based upon the amount of equity that's been paid down. Well, in that statute that addresses those time limits, it goes through and it says, well, what constitutes payment on the principal of the agreement for sale or payment on the purchase price of the agreement for sale? And it lists out, the initial payment that's made, principal payments made to the seller. And then finally, the third one is payments made to third parties who have liens against the property that remained or existed prior to the agreement for sale and remained after the execution of the agreement for sale. So our statutes in Arizona contemplate a subject to transaction, at least as to an agreement for sale. So there's no issue there. The big issue I think that people are concerned about and take issue with is the due on sale clause. They say, well, you're going to violate the due on sale clause. That's a breach of the contract. And if you actually take a look at the due on sale clause, and especially if you look at the Fannie Mae Freddie Mac due on sale clause, there's other ones. FHA has their own due on sale, private lender, like credit unions and other banks that have their own portfolio loans, they're going to have their own due on sale clause. But if you look at the big one, which is the Fannie Mae Freddie Mac due on sale clause, over and over it uses the term option. If the seller conveys the property or transfers the property, then the lender has the option to accelerate the loan balance. And it even uses the term at one point, if they elect this option. So it's an election. It basically is not an immediate or automatic breach of the deed of trust. Instead, it provides the lender with an additional contractual right. It's a bargain for exchange saying, hey, look, seller, if you go and sell it, I as the lender have this other contractual right. I now have the option, if I choose to move forward with it, of accelerating the debt. So in my mind, it's not a breach, or in my position is it's not a breach, especially as to that specific due on sale clause. But even assuming it is a breach, is that illegal? And once again, there's case authority. The Sixth Circuit has plain language, saying no, a breach of contract is not illegal. There's the legal theory of efficient breach. And then we also have a number of state bar opinions throughout the country that have addressed this particular issue. And a real short one that I want to read from the Virginia State Bar is an ethics opinion asking, okay, what's an attorney's duty when they're involved in a subject to transaction and preparing the paperwork for a subject to transaction? What is their duty? And it's just a little paragraph here, so I'll read it. It says, there is no duty on the part of an attorney to advise the holder of the first deed of trust, who is not his client, that a violation of the terms of the deed of trust have occurred in a subsequent closing. The attorney, however, must disclose to his client that the client's conduct is in violation of the terms of the deed of trust, and must explain the likely consequences of such violation. So when I read that, my takeaway is you can move forward as an attorney, as a professional. You can move forward with assisting a client or preparing documents for a client to either acquire or sell the property subject to. But the key is to do it right and to fully, especially if you represent the seller and even the buyer, you should be disclosing this stuff. But if you represent the seller, your duty, though, and to do it right, is you have to have disclosures to that seller, basically detailing and outlining, look, this is what you're doing, and here are the potential ramifications and consequences. And if you do that, you've complied with your duties and obligations as an attorney, and you've complied with your professional obligations. So subject twos are not illegal. They can be done as long as the parties involved are advised of the potential consequences of the due on sale clause and what that might look like if the lender moves forward with it.
Very interesting. Thank you for that. Good legal update. With that, let's talk about some of the news and legal updates that we have coming here in the very near future with INRAM. We've got our next Creative Finance Symposium. Sean, why don't you give our listeners a little idea about what we're going to be talking about at this Thursday's Creative Finance Symposium?
Yeah, so the Creative Finance Symposium will be Thursday from 6 to 7 p.m. Arizona time. And our topic is agreements for sale. And we're going to go over the statute that I was referencing and talk about, at least here in Arizona, the forfeiture timeframes and things like that, as well as just overall key provisions that you're going to want to have in an agreement for sale. Some other states call it contract for deed or land installment contract. But we're going to be going through the key provisions that you would want to see in there from an acquisition and investor perspective. And then we always reserve the last 30 minutes of the symposium to answer real estate law related questions and provide education in that area to those who are in attendance. It is a closed session, meaning you have to, it's free, but you have to register and you have to then attend. We do not publish the recording of the symposium. It's not available later on. We don't provide even recordings to those who are in attendance. So you have to attend to receive the content. You have to attend to participate, to ask any questions. But that will be from 6 to 7 this Thursday night.
All right. And so make sure to join us. It should be a good event this Thursday, 6 p.m. to 7. It's a hard start, a hard stop, right? So make sure to be there. We'll be starting right away at 6 and probably ending at 7, but we'll be there to answer your questions. You're also speaking April 21st. Why don't you tell us about that?
Yeah, so April 21st, I'm going to be speaking from 2 to 6:30 p.m. Arizona time. It's an in-person event here in Tempe. And the title is How to Legally Use Creative Finance to Double Your Business. And it's designed for real estate agents in particular to basically learn and understand the different creative finance methods. My topic will be legality of subject to transactions. And so my preview today is just a little snippet of what I'm going to be talking about. On Friday, I will be presenting along with real estate investor Pace Morby and branch manager, escrow officer Eileen Brown of American Title Service Agency, who does a high volume of subject to transactions here in Arizona.
All right, very good information. All right, just a reminder for those that are watching, we also take questions, and we'll be taking questions today on the show. We try to reserve the final 15 minutes or so of the program for questions that you might have for us or for our guests. So make sure to join us for that. I'm going to turn it over to Mayu, who can give you directions on how to go about doing that.
Hi, and happy Tuesday, everyone. Thank you for joining us live on the INREM podcast today. Andy's right. As you may know, Andy, Sean, and our guest today will be taking questions live on the show. If you're watching the INREM podcast, whether it's from our Facebook or YouTube pages, we are monitoring the chat for your questions so that we can take the last 10 to 15 minutes of the show to answer them. We take questions in order of priority, so don't wait. If you have a great question in mind related to today's topic, which is subject to tax-free, make sure to leave it in the chat and we'll try to get to all the questions at the end. So without further ado, let's get into our discussion today.
All right, thank you, Mayu. All right, let's talk about and get into our topic. Today we're talking about doing subject to transactions or doing SubTo tax-free. And with us to discuss that topic is attorney Jeff Watson. Jeff is an attorney with the Jeffrey F. Watson Law Firm, Ltd. Jeff Watson's website, you can find it here on the screen at watsoninvested.com. That's watsoninvested.com. And we really appreciate Jeff being here. Jeff, thanks so much for joining the show.
It's my pleasure to be here. I'm enjoying this. And just, I love hearing other good lawyers explain why common thought is wrong. The detailed discussion about why subject to is not illegal, I really enjoyed it. And I'll just share with you, I had an epiphany a little over a year ago. I'd been watching this market and I knew subject to was a thing and I was really concerned about it. Dug into some tax court cases with my good friend John Heyer. And John and I were looking at what the United States tax court was saying about subject to. And they just see it as a normal business transaction. And I'm like, if the federal tax court's good with it, I'm really good with it. Let's go, baby.
Yeah, exactly. Well, Jeff, tell our audience a little bit about yourself. Give us an intro, a couple sentence introduction about yourself and what your industry and area of expertise is.
So, thank you. I'm a lawyer, licensed practice in the state of Ohio. I've been doing it now for 32 years. Still trying to figure out how to do it right because practice makes perfect, and I'm still practicing. Right now, today, a lot of my practice is focused on real estate transactions and self-directed IRA transactions. Those are the big things for me. I do some other stuff, but not nearly to the degree. I also am involved pretty extensively in political advocacy at the national level in Washington, D.C., and we might talk about that a little bit later today. We might not. But it's something that has to be done. And I've been doing it now for 10 years. And I bring to the table in my transactions the mindset of how do we do this deal so it's done correctly, done right, and it will not create a train wreck for someone to politicize or publicize to advance for an argument for more regulation, more control, and less property rights, less freedom. And so that's an underlying principle of what I use in how I do this stuff. And I've done things like I've spent all day on Capitol Hill with members of Congress on multiple occasions. I've spent time at CFPB arguing for the validity of land installment contracts, agreements for deed, bond for deed, whatever you call it in your particular state. That was an interesting day. I was clearly in the minority, but we prevailed. We did okay there. I've done a lot of other stuff regarding legislation and lobbying work there, but my passion, my real big passion, is showing real estate investors that there are ways to structure deals to where they win, the other party wins, and the IRS, well, it just doesn't go so well for the IRS. They don't make as much as they could otherwise make in taxes. That's one of my biggest passions.
Jeff, I can tell that this type of work is not just what you do, but is important to you. Why is it so important to you?
I think it has to do with, I see America as the best place in the world where in one generation you can go from a dirt poor kid in the country who doesn't even know his own daddy to a multimillionaire. And I see real estate as one of the best vehicles to do it. The two things that I think are the biggest poverty busters in America are quality education and real estate investing.
So you offer a newsletter that goes out a couple times a week. Tell us a little bit about that and how our listeners can sign up to be involved with that.
So I do a free email newsletter. Hopefully it goes out twice a week. I know this week it will. And it's worth what you pay for it, at least, okay, since it's free. You can get it by going to watsoninvested.com and registering. Just put in your email address and your name at watsoninvested.com. All one word, watsoninvested.com. Takes you to my blog, and right there's the opportunity to go ahead and sign in to register for the free email newsletter. And I keep the list pretty manageable. I don't, if you don't open it up and read it for 6 months, I take you off. You're obviously not interested, so I take you off. So I keep the list at a pretty good size. And I will tell you the open rate is probably in the mid 20%. So I'm pretty proud of how that's working, And
yeah. For those listeners that get through the episode and think, wow, he's got a handle on this, and they're in your area, and they're thinking he's our guy. How do they go about best procuring your services and getting in?
Well, that's a really good question. And if it's an IRA transaction, I can do it outside the state of Ohio. If it's a real estate transaction, I will do it inside the state of Ohio, or I'll work with local accounts outside. And once again, the best way to get started is right there on my blog, watsoninvested.com. You can fill out the form to schedule a consultation, and we take it from there. And we just, we'll review the form, and if it's something that I can help you with, we'll reach out and set up a time. We'll go from there. If it's something I can't help you with, we'll shoot you back a quick email saying, no, I can't do it. And sometimes, believe it or not, I have things where it's a conflict of interest, and so I can't touch it. So I have to screen everything before. I want to screen it before I get on the phone with somebody, before they share something with me that they shouldn't tell me because of who else I represent.
So before we get into and dive into our subject today, do you have any nuggets of wisdom for our listeners today from a seasoned lawyer and investor?
That's a wide open question, man. I'm glad you asked it. I would tell you that all that glitters is not gold. Know your numbers. Some of the clients I'm working with right now, getting them out of some really precarious deals and some bad structures is because they didn't take time to track and know their numbers. And where they thought they were going to make 6 figures on a flip, by the time they get done really knowing what the numbers are, and after taxes, they're barely making 10 grand. And they're looking back at it going, I spent all that time working for that little bit. So know your numbers, track and know your numbers. It's so important that we do that. And always, always, always do your due diligence on both the people, the property, and the paperwork. As my friend Jim Ingersoll would use those alliteratives: people, property, and paperwork. Do the due diligence on all 3.
So as we get into this topics, doing subject to transactions, tax-free, we want to set the table here a little bit and back up before we get into the tax-free side of it. And we've spoken on this show with a number of attorneys, and subject to transactions are a hot topic out there right now for a variety of different reasons. But we'd like to hear and find out from you, how do you define and what is a subject to transaction?
Great question. I define a subject to transaction where the buyer is receiving title to the property without the satisfaction and release of existing liens or encumbrances, voluntary liens or encumbrances, such as mortgages or deeds of trust. And that in conjunction with that transfer of title via deed, there's an agreement between the buyer and the seller that the buyer will begin paying without legally assuming, but paying those same liens or encumbrances or mortgages or deeds of trust, whatever you want to call it. Just keep the monthly payment going. That's how I would describe the fundamental characteristic of a subject to.
And just kind of a follow-up to that same line of questioning, how do you like to structure, or do you have a preferred method of structuring a subject to transaction?
Oh, I do. I have a cookie cutter method. I create what I call a grantor revocable title holding trust, of which I, the investor, am the grantor. My multi-member LLC that buy and holds my real estate is the beneficiary of that trust. And the trustee of that trust is the person who actually enters into the subject to transaction. The property that we're buying subject to is titled into the name of the trustee of that trust. And that's how I love to take title to them. And so then it gives me a degree of anonymity. It gives me a degree of privacy. It also gives me just a little bit more of a confused minds don't understand what you did, so they're going to leave you alone perspective, if you know what I mean. Yeah. But under no circumstances do I labor under the illusion, or do I want anybody to think I'm suggesting the illusion that using what I call a grantor revocable title holding trust, what others would refer to as land trust, but I don't like that term because it's so badly beat up and ugly with some really horrible teaching about it by non-lawyers. I don't want anybody to think that that usage of a trust is to try and comply with the Garn-St. Germain Act. There is no way a subject to transaction can comply with Garn-St. Germain. So trying to go through the mechanisms of it is just, it's wasteful, in my humble opinion.
Jeff, do you also structure the transaction so the buyer is the trustee of the trust, that's the purchaser? Do you also then have the trust execute a note and mortgage or deed of trust back to the seller as well, and do a traditional wrap transaction?
If I'm financing the seller's equity, yes.
Okay.
If the seller has no equity, then there's no need for it. Just, yeah. But if there is, yeah. Now, but I want to be careful, because wraps are not subject twos and subject twos are not wraps, particularly in the eyes of the tax court.
Okay.
And so we spend I want to spend a little bit of time here being very clear that when I buy a property subject to, the tax court sees that as an assumption. But if I buy a property with a wrap, the tax court does not see that as an assumption, and they don't see any forgiveness of debt. And so and it really matters in the situation where an investor is buying from a landlord who has refied the property. And so now that their debt is in excess of their basis, if you do a subject to transaction there, you have triggered phantom income tax on that selling landlord. If you do it if you structure it as a wrap, no phantom tax occurs.
So in some cases, there would be a tax benefit to the seller to do a wrap transaction as opposed to a subject to with a
Yep. Yeah. And my good friend John Heyer and I, we've created a course on that. That's part of a bigger SubTo course that I have, where he and I spent 6 hours just, John, you know how he is with the tax code, and he and I just geek out on it for 6 hours about how to do this stuff. And we break down installment sales, we break down phantom income tax, we break down all that stuff. And it's much needed information that the marketplace needs to hear and see.
Yeah,
because the people just don't get it. They don't get it. So we'll leave it at that.
Now, does the buyer's ability to, I know this is a little different, but we are talking SubTo tax-free, so we'll talk about it for a minute if you know the answer. If you purchase using the land trust with no corresponding note and deed of trust as opposed to the wrap transaction, do either of those structures impact the ability of the buyer to claim the mortgage interest deduction?
No, the buyer is able to claim mortgage interest deduction either way, because it comes down to this: who actually made the payment that contains the interest portion to it? Who made it? The payment to the bank. And so in a wrap situation, I'm wondering if maybe there isn't a double interest deduction. I think you can split it apart. But in a straight SubTo, the buyer or the trustee who's making those payments, or actually it falls to the multiple member LLC that's the beneficiary of the trust, gets to claim that interest deduction on its 1120, I believe. I'm not sure. I can't remember what a partnership tax return is. I think I can't remember if it's an 1120 or something else. My brain's not working there today. So yeah, and I mean, here it is on tax day, and I can't tell you which tax form to use. I'm sorry, folks.
Oh man, are we there? Is it tax day? Oh, I knew there was something to do.
Well, it's Taco Tuesday and Extension Day for me. Okay.
Oh, that's funny. So talk to us about what you perceive as the biggest benefits to the subject-to transaction, and following beyond that, what you assess are the biggest risks to a subject-to transaction.
So let me give you the benefits from both sides of the equation. For the seller, selling a property subject to a buyer who has integrity and who is going to stay in the deal, that seller can benefit by getting rid of a problem property that they otherwise is going to pull them under. We're watching people right now in certain communities getting forced out because of the escalating insurance costs and real estate taxes, pushing their house payments up beyond what they can afford. Those are people that, because their income can't go up, because they can't figure out how to make a side hustle happen or whatever, they've got to get out. So that's somebody who can sell, and a SubTo transaction can work for them because they don't have enough money to pay an agent to list the property, cover the seller concessions and everything else. They don't have the money. So that's a benefit to the seller. The benefit to the investor buyer, and usually I speak in the terms of the investor buyer, is you can now acquire a good quality property in a good neighborhood with better financing already in place than what the marketplace will give you now. I mean, right now, I'm thrilled to get from a private lender. I'm thrilled to get money at 8%. I'm just ecstatic to get private money at 8%. And I wholeheartedly will pay my private people 2 points higher than what I'll pay a bank, just because of the value of private money. But if I can go buy a piece of property and I can take advantage of a 2.75 or a 3.25% fixed rate mortgage for the next 20 plus years, that's just gravy that I've got to go put on my biscuit, if you know what I mean. I got to go get it.
Well, I want to address that a little bit, because I've seen this, and I've been doing a lot of thinking about this. Is, you talked about a problem property, et cetera, but what about a seller who actually has equity in the property, but a 2.75 interest rate? We're in a unique circumstance where I don't know that we've ever seen this, where, when the market turned in 2008, I think the best interest rate you were getting maybe 5.5 at some point, 6%. We never saw it where it was so low, and now it's shot up, fairly high. Where to me, let's say you have a seller, house is worth $500,000. They have a $400,000 loan at 2.75%. The best the buyer can do is 6.5. To me, the seller has two assets. They have the fair market value of the property, but they also have a loan at 2.75%. Is there any opportunity for a seller to actually say, look, my house is worth 500, but I'll sell it creatively or subject to, but you're going to pay a premium. You're going to pay 510, 515, some number above the 500.
I have had those negotiations with sellers. I have had sellers that were that savvy that they knew what they had. Right. And they wanted an extra $25K down to do a SubTo sale.
Yeah.
Yeah.
And a smart buyer will pay that when you do the numbers.
A smart buyer should lunge at that deal.
Exactly. And that's what I don't understand too about the real estate community right now, is there really is this, battle, animosity between the real estate professionals and the investors. And, slowly but surely walls are being broken down, but there really is. But man, if I were a real estate professional, I would be educated on this and say, hey, look, seller, I have a deal for you. You know, let's negotiate. Let's use that other asset that you have besides just the house and get and have some more money. And of course the seller has to be in the right spot. They have to maybe be able to qualify for both, you know, if they want to buy another house, qualify for both houses and all that good stuff. But, you know, let's use that and you know, sell your property over what you could, the fair market value is.
Right. And let's face it, we already see this happen on a regular basis in the commercial space with multifamily. That's got that fixed rate, long-term low interest rate that's assumable. I mean, I've talked to multifamily operators. They know what they've got. Right. They know the premium that they can get for that. It's just, you're right. It's a matter of real estate agents that are committed to doing their craft well, to expressing that to their sellers and helping them understand it. But I'm gonna back up and I'm gonna give you guys a curveball, because I've really been bothered by a term that we've been throwing around in our culture for a while now. And that's the term conventional lending. I submit to you, it's not conventional lending. It's new version of lending. I mean, when I came out of high school in 1982, we did not take and pool mortgages into huge jumbo packages and sell them to bond funds spread across the world. We didn't do that stuff. We still had local savings and loans banks that were doing this stuff. And so to me, what we've seen in the last 40 years of lending that we now call conventional, to me, is the new version. Seller financing has been prevalent in this country since 1776, since this country was founded. And let's just not forget that. But, you know, the big institutions that profit off the fees and the churn and all that other stuff, they want us to think that what they do is the conventional way of doing it. And I'm like, not so.
Right. No, I'm with you. Yeah, it's definitely different than, say, even 20, 30 years ago. So.
Oh, it is. It's radically different. It's radically different. I mean, the S&L crisis was a triggering event. And, you know, we could talk about what triggered the S&L crisis, but, you know, my attitude is when you change the tax code that dramatically, it's going to have all sorts of ripple effects a la 1986. But anyhow, yeah.
So Jeff, we've been talking about the subject to seller financing, creative financing side of this. Let's flip now to the taxation side of this and do a little bit more table setting. But why don't you explain to our listeners the typical types of taxes that a real estate investor should expect to come face to face with?
Sure. So the typical real estate investment transaction is going to result in taxation on one of four or more, up to 4 different areas of income. You're going to have taxation on rental income. You can have taxation on interest income. You can have taxation on short-term capital gains or ordinary income. And you can have taxation on long-term capital gains. And yes, I lumped ordinary income and short-term gains in the same category, and I probably shouldn't have. But, you know, an assignment fee is ordinary income. You own a house for 1.5 years and you sell it and you make a gain, that's a long-term capital gain. You rent a property out after expenses, after depreciation, after all the other stuff. If you got anything left, it's subject to income tax. It's the net income, net rent. You lend money out, you get interest payments back on it. That's being taxed as well. So the idea that we look at is there a way to minimize the taxation on real estate deals? We're always looking for ways to minimize the taxation. So it was just, so it comes to my mind. And then, so I've been playing with the subject to space and looking at it. And I mean, I remember, it was several months ago, I was in the office and I picked up a file and I looked at a SubTo deal I did 20 years ago. And so I started flipping through the folder of this actual deal that I did where I was the investor buyer. And I looked at the paperwork, I looked at how I set up the deal, I looked at how I ran it. And I go, man, so much I'd change now. So many things I'd do differently, better. So, but anyhow, then Secure 2.0 passed the House and the Senate. It got signed into law by President Biden. And there was a little gift in there that clarified something. And so then my creative mind, because I love IRAs and Roth IRAs in particular, my creative mind said, there might be a way to mitigate some more taxes here. Let's just play with this. And so I thought about it for a while and I looked at it and I said, if I bring in a brand new Roth IRA, one that was established in 2023, Could be funded with a brand new contribution, could be funded with a rollover from an existing Roth, whatever. But if it's a Roth that's clearly opened and established in 2023, so it clearly fits under Secure 2.0, and I go do an aggressive deal with it and it blows up, it by federal law cannot affect anything else I own in any other IRA. And so I'm like, okay, we're going to have some little prodigy IRAs. We're going to start doing some really push the limit stuff. You know, leave the mothership alone, leave it safe and protected. We're going to move a little bit over into some of these other accounts, and we're going to start doing some pretty cutting edge stuff. So I've been showing people how to take a Roth IRA that you form in 2023, you fund it correctly, either with a new contribution, money moved in from somewhere else, however you want to do it, and then go do a SubTo deal with that Roth IRA. And you can minimize those taxes, but you open yourself up to just one other tax, but you can play that game as well. So, yeah, if I can get rid of 4 or 5 potential taxes and get down to where I have one and I got a chance to play games with that one, I'm a happier guy, if you know what I mean.
Yeah, so there's a lot to unpack there, I think.
Yes, there is. Yes, there is.
Why don't we start with because what the listeners hearing, what I'm hearing, what we're all hearing is less taxes. That sounds great. Let's do it. So,
well, not only less taxes, but money that will continue to grow tax-free in the future and get pulled out and spent tax-free at some point in time in either my life or my beneficiary's lifetime. And if that doesn't get you excited, then I'm going to check to see if you got a pulse.
Okay, so let's go ahead and unpack this. I think we've got at least 6 hours to go, so we should be able to fully flesh this out right now.
Okay.
So where do we start? I'm an investor. I've come to you. I've heard the show, and this sounds awesome. Where do I need to begin? Because it sounds like my old IRA is not, or my old self-directed IRA is not going to work. Is that right?
So I'm going to start with this because I want to be very clear that this concept is a very, very advanced concept. We're taking 2 very powerful structures and we're putting them together. So I'm going to start out by saying that if you have not already done a subject to transaction, don't do your first one with a Roth IRA. Get a couple under your belt where you can see how they flow and you don't have to worry about all the IRA rules. The second thing I'm going to tell you is if you've never done a deal with a self-directed retirement account, excuse me, you better go do something with it, okay? So you can get familiar with how your custodian or administrator operates and processes and so on. But once you get those 2 things done, and you've got a degree of comfort and you've got a degree of skill, this isn't your first rodeo, you're not fresh out of a seminar, you've done a few deals, you've made a few loans, you've bought and sold a few houses, you're familiar with the verbiage, the vocabulary, the mechanisms, then we can get after this. And so the first thing I would tell you is, once we hit all those criteria, then we want to open up a brand new Roth IRA. Because Secure Act 2.0 was very clear that it applies on accounts opened in 23 and beyond. Okay, so I want to grab that because I don't want there to be any dispute that this aggressive deal I did, if it ever gets audited, if it ever gets questioned, doesn't contaminate the hundreds of thousands of dollars I may have somewhere else in another IRA. So I want to do it with just a brand new IRA. Then I'm going to move money to that brand new IRA account. And then I have to make the decision of, am I going to do it in the IRA or am I going to take the extra step of creating an IRA owned LLC? If you plan on doing this more than once, I would say take the extra step, set up the IRA owned LLC. And oh, by the way, if you are setting up an IRA owned LLC, you can set it up to where that LLC is owned by more than one IRA, more than one of your IRAs, more than one family member's IRAs, etc. And so that answers one of the questions that was that been sent in earlier. Yes, you can do it, but don't do it alone. Make sure you're working with good, competent counsel to do that, because there's things you need to be aware of. There's some special rules you've got to be aware of. Then once you've got that IRA set up, and you've maybe gone to the step of setting up the IRA owned LLC, Then it's start looking for a good SubTo deal. Look for a good SubTo deal. I mean, my marketing campaign is so simple. It's so basic. It is reputation and relationship only marketing campaign. I don't do any marketing, no postcards, no SMS, no mail, nothing, no pay-per-click, nothing. I just have deals come to me because people know I can fix deals, I can solve them. So I'll have deals come to me. I had a deal come to me about 6 weeks ago. We closed on it last week. We bought 3 houses SubTo, smooth piece of cake deal. So look for the right deal. And you want to look for a deal, in my humble opinion, that you're going to do one of two things with. You're going to hold it long-term as a cash flow producing rental property, or you're going to buy it, improve it, and sell it to a non-bankable but strong down payment buyer. We'll exit out one of those two ways so that the capital gains flows back into the IRA, so that the rent flows back into the IRA, so that the interest income flows back into the IRA, depending on which way you go. And then at some point in time, you're going to get it amortized down well enough that you may choose to sell the property and drop all that money tax-free right into your IRA. Yes, you're going to have to worry about UBIT, but it's so fact-specific, number-specific. I don't want to get lost in the weeds of UBIT today. But that's the way I see these deals happening. That's the way I've been coaching people to do them.
Jeff, so there's obviously contribution limits to Roth IRAs.
Yes,
per year.
but there's not rollover and conversion limits.
Correct, yes. So, we have on here on our sheet, where do we start? In my view, you start young. Start investing now, right?
Yes.
Yes. Your IRA, because you have to have that level of capital in there, and you have limits, and so you have to build it up in order to be aggressive and do your method of this type of transaction.
And there's also other little things you can do. If you don't have money to roll over from another IRA, if you don't have money to convert from another IRA or orphan 401k, there's still another strategy out there. And that is your IRA can borrow on a non-recourse basis. Bring in a private lender on the deal to get you that extra bump of capital that you need. Bring that in, and look at if the property will cash flow and support that. Bring that person in, give them a second position lien, and let them get fed off the cash flow. Maybe they'll even come in on a profit participation basis, and go from there.
Yeah, it seems like the subject to industry might give a lot of investors that wanted to get into real estate and otherwise thought that they couldn't because of the price point, a new access into the industry, because if they're basically by another name but taking over an old loan, really they're only worried about what they're bringing to the table on the day of closing, right? Which is significantly less than the entire purchase price. So I would imagine that opens this up to a lot more investors.
So it opens it up to a lot more investing because it requires a different form of capital to do this. Instead of dollars and cents, it requires intelligence and relationships. And I'm sorry, anybody's out there, anybody can get out there and get the intelligence, get the information, learn it. Anybody can work to build some of those relationships. And then they can then merge onto the freeway of real estate investing through the SubTo on-ramp and go. They don't need a pile of money now. If they've got the intelligence, the information, the relationship, go do it, get it done. There's no excuses.
Right. Explain to me, and I know you've explained this, but part of me missed it, but why is it that we can't use a previous self-directed IRA to do this, where you're recommending doing it now and do 2023?
So I didn't say you can't use it, but I'm glad you're getting me to clarify that. I don't recommend that you do, because I want to take advantage of some specific language enacted in the Secure 2.0 bill that passed Congress last December, where it specifically says that for tax qualified accounts, IRAs, particularly Roth IRAs, established in 2023 and beyond, if a prohibited transaction occurs in that account, the penalty is limited to that account. It does not go against any other account that you may have. Now, that's what we felt the law was all along, but it's really nice to have it clarified and codified. And so I'm like, I'm going to take this thing that they give me and I'm going to wrap myself around it and I'm going to run with it. You know, if they give me this statement in the, you know, that prohibited transactions in 2023 and beyond and accounts established in 2023 and beyond are limited to that particular unique only account, I'm grabbing it, I'm running with it.
So the new law provides really kind of a blanket of protection as to your other assets should you run afoul.
Yes. It protects me. It protects all my other tax qualified accounts, all my other assets. Yes. Yep.
So are you seeing a lot of individuals, investors, clients wanting to take advantage of this strategy?
I'm seeing a few, not many, because a lot of them are still like figuring it all out because, you know, once you start pulling these two things together, it's a higher level work. I see a lot of clients still doing SubTo deals. Got a lot of clients doing that. That's a lot of fun. But the mentality amongst many of them is, Jeff, I'm doing it for eat money. I'm doing it for eat money. And I'm like, man, beans and rice, baby. Beans and rice. You know, skip the pizza on Fridays, you know, whatever, beans and rice, and do one deal in a Roth IRA. If you're doing 4 or 5 deals, do one in a Roth. You can live off the remainder, you know.
Now you mentioned that you recommend that an investor play with this a little bit before they dive in on this. And how long does it take to, if I'm coming to this new and I want to get into this and I'm going to need to create a self-directed IRA, or maybe I've got one, but I want to take advantage of all the protections you've talked about. I mean, how much time realistically should I expect this to take?
That's a really good question. You can establish a brand new IRA account with many of the custodians that you and I both know that allow you self-direction. You can get that account established and funded in 7 days or less. That's not a time barrier. The process of then establishing the IRA owned LLC, if you're going to go that route, that might take a few more weeks to find a quality attorney that can draft the operating agreement, make sure the tax ID number is correctly assigned, make sure all the wording and titling is correctly done. That could take a little bit longer. But the biggest challenge is I don't want somebody doing their first SubTo deal in an IRA. I want somebody to be doing their 3rd, their 4th, their 5th SubTo deal in an IRA, because I want them to be really comfortable with the mechanics of what's involved, so that they don't do a blatant prohibited transaction by performing obvious services or, you know, benefit to the account by doing it. Okay, that's my biggest warning.
Yeah, that makes a lot of sense. I think we have some questions from our listeners. Maya, you want to turn it over to you and let us go ahead and give it to us.
Yep, and now it's time for our favorite part of the show, is when you ask your questions and we get to answer them. So I'm going to go in order of priority. I'm going to display it on the screen so that you guys can see the question, and then I'll turn it over to you so you can answer. So our first question here from one of our audience on Facebook: can you create an SD IRA LLC with checkbook control and then have multiple IRA funds combined to have more to invest in real estate?
The answer to the question is yes, you can. Consult with an attorney on establishing the correct type of LLC with the correct operating agreement, so that you know that you can only fund it one time and one time only. But yes, you can do that.
Great. Now we'll move on to our next question. This one is from Raif, watching us from YouTube. Sorry if I mispronounced that. What are the best exit strategies in 2023 in case the bank demands the whole mortgage payment? Worst case, what could be done? Sell, refinance, negotiate with the bank, legal challenge?
Okay, so everybody's afraid of the boogeyman, even though the boogeyman rarely ever shows up. But the best exit strategies that I've seen are refinance with a private lender, sell it if you need to, deed it back if you absolutely have to, and if that'll make the bank be happy, you deed it back and then just restructure the deal as a lease with option to buy, master lease with option to buy. Negotiating with the bank is probably going to be a waste of time where you're going to be beating your head on a concrete wall, so don't do it. And I don't see where you've got much to argue with on a legal challenge. I wouldn't waste money on attorneys for that. So I would either refinance it with private money, or if you sell it, you sell it. If you can restructure the deal in order to pacify the bank, go ahead and restructure the deal. I see 3 ways out. Yeah.
Wow, you're knocking these questions out. Maybe you can answer this next one, Jeff. And this is the last question we have, which is, can an IRA-owned LLC be owned by an SEP IRA to get higher contributions?
Yes. However, unless your custodian is on the cutting edge, your SEP is a traditional IRA. And that means that the money that you make with that IRA-owned LLC, now it's owned by your self-employed person IRA with higher contributions, it's still all traditional dollars. And so you're just making money that's going to be tax infested later on. And so when you take it out, you're going to pay taxes on it. So I would tell you to look at taking and rolling that SEP into a Roth if possible, or establishing a Roth SEP LLC, which Secure 2.0 finally allowed us to do. And the custodians are still trying to figure out how to do all that. But that's what I would tell you to look at.
All right, good questions. Thank you.
And I got to tell you, Andy, Sean, those are high-level questions. Those are not questions from somebody going, what's a deed and how do you invest in real estate? Those are people who know what they're asking. Kudos to them and your audience. Yeah.
Yeah, they're high level folks. They keep us accountable.
Yeah.
We're gonna have to make sure to bring our A game every week. So, Jeff, tell us what else you have going on. You have anything new going on in Washington, D.C.?
I do. Today, I wired a $10,000 retainer to a law firm in D.C. for forming my own political action committee.
Oh, wow.
Real Estate Note Investors United. I am taking on this foolish notion of a renter's bill of rights and this fascist concept called rent control. Fascism, as defined in the textbooks, show us that when private people who own the asset are told by government authorities what they can do with it, when they can do with it, and how they can do with it, at what price points, that's fascism. That's rent control. And so I am taking that on head on. We've had some great early success. I can tell your listeners that there will be no funding coming out of the House Appropriations Committee for anything that President Biden wants to do with his Renters' Bill of Rights. We have successfully built a bipartisan coalition of senior ranking members of that committee to put a squash on any dollars going that way. So, but this is not a fight you win one day and then you give up and you walk away. This is the next decade of my life. The real estate investing industry for far, far, far too long has not had a seat at the table. And 10 years ago, we began building a seat at the table when Freddie Mac and Fannie Mae issued an underwriting bulletin that specifically targeted a real estate transaction methodology that I had co-pioneered. And so we pushed back on Freddie Mac and Fannie Mae. So we got a little bit of a presence there. Then we started working with our good friends in Texas on the Seller Finance Coalition, brought on National RIA, brought on some other organizations, and we used the Seller Finance Coalition to create a presence in DC regarding seller financing. We leveraged that platform in 21 to kill the horrible sections in the Build Back Better bill. And we managed to use the relationships from the Seller Finance Coalition to get in front of the right legislators to kill that part. You know, John Hyer's website of Hands Off My IRA and tens of thousands of individuals calling and phoning and faxing and emailing is what made the difference. And so from that momentum, I've decided that you could build a parallel organization to the Seller Finance Coalition, but build it bigger and build it stronger to where we can raise funds, support the right candidates, and continue to influence housing policy to where the individual property rights of people who own real estate to build wealth, provide safe, affordable housing are unmolested by some of the would-be tyrants in Washington, D.C.
So the biggest
Do you
question.
think you think I'm a little passionate about this?
Well, yeah, what I was thinking is, when do you find time to sleep? I'm already ready for a nap, but there's so much going on. Well, we know that you're an involved guy and that you're in the real estate space, and we really appreciate you coming on today. Jeff, give our listeners one more time, how can they find you and connect with you?
Sure. The best way to find me, the best way to connect with me is through my blog, watsoninvested.com, watsoninvested.com. You can also find me on Facebook, Watson Invested as well. And if you're seeing the great marketing done by Andy and Sean and team, then you've seen that on Facebook and elsewhere, so you can connect with me that way. I have really enjoyed this time. I always learn something when I come on with you guys, and it's been a pleasure. It's been an honor.
Well,
and I'm looking forward to, hopefully you guys will have me come back again, because I'm so mild-mannered and soft-spoken. You might let me come back again. You never know.
Yeah, we can't wait. You always have a space here. We appreciate you taking the time. Love having you, and look forward to the next time.
All right. Peace.
Jeff. We'll talk to you soon. Thanks so much. All right, everybody, that is our show for the week. Make sure to join us next week. We're talking about the intersection of community property, divorce, and real estate. We'll see you next week.
Have a good day, everyone.